right, everybody. Let me see. This is going to be day 3, which is ethics. Okay. We're going to cover representation as a whole. Okay. Now, sometimes people get a little bit confused about what encompasses representation. All right. When you're an enrolled agent, you are allowed to represent anybody before the IRS. You're also allowed to represent entities before the IRS, like a partnership or a corporation or anything like that. You have unlimited practice rights before the Internal Revenue Service. Now, there are some tax practitioners that have made an entire industry out of this. They want to do rep work, and some of them don't even really do tax returns. They just do rep work. So tax accountants that don't want to do rep work refer people to these like bulldog rep guys. And I say guys because I've never met a woman that actually did this. There was like that Ronnie Deutsch, who was remember her? She was a lawyer. There used to be all kinds of, she got in trouble. So that's the only other one that I've ever heard of that was a woman that did representation on a regular basis. I personally don't really like it that much, but I will do it for my existing clients. I don't take on cases where they're not already my clients. But there are some people, there are some practitioners that really enjoy doing this type of work, and there's a lot of money in it if you're good at it. Okay, we're going to cover Circular 230 Ethics. This is the circular that governs tax professionals, okay? And it's a pub. Just like Publication 17. It's called a circular, I don't know why, but it's an IRS publication that explains the rules and regulations that apply to us as preparers. We're going to talk about rep work itself, the rules for e-filing, the U.S. tax court, and other tax professional requirements. Okay, so that's what we're going to cover today. Okay. Now, for the exam, you need to know a little bit about our beloved federal tax law system, okay? Whenever you see IRC, okay, they're talking about the Internal Revenue Code, all right? It is an area of U.S. law, and it is the main body of tax law of the United States. It's not all of the tax law is in the Internal Revenue Code, but most of it is, 99.9%. The IRC is enacted by Congress, and it's published in Title 26. There's a very good chance you're going to see that number. You need to know if it's Title 26 of the United States Code. So the United States Code is all the laws of the U.S., and the Internal Revenue Code that has to do with tax law specifically is going to be in Title 26, okay? The IRS Enrolled Agent exam only deals with federal tax law. And you're not going to encounter any tax law that's particular to a state or municipality. When you're actually a tax preparer, you have to deal with that anyway, right? So if you're in a state that has state tax, or if you're in a city, some cities will have a city tax as well. Like New York has 3 tax returns. It's a city, a county, whatever, and then you have the state tax return, and then you have the federal return, okay? So the only thing you might see on the EA exam that has to do with the state is perhaps community property, maybe. And there is also a possibility that you will see something having to do with common law, marriage, okay? That's the only thing that you might see, all right? Because state law determines marital status, except for the DOMA case, which now has said that if you're married, same-sex marriage in any state, the state that you're in has to recognize that too. So, so that's the only reason why I think you might see a possible question about that. Okay, tax law is determined by all 3 branches of the government. Even though Congress is where most tax law originates, okay, that's not where we get all of our guidance. Not all of our guidance comes from the actual Internal Revenue Code, okay? The legislative branch of our government, which is Congress, has the primary function of originating the tax law. They're the ones that come up with all the tax law, good or bad, okay? The executive branch, which is the President of the United States, is going to be responsible for income tax regulations, revenue rulings, and revenue procedures. Okay? Technically, Obama's not sitting there in his chair and saying, I'm going to write a revenue ruling today, right? So the Internal Revenue Service and the Department of the Treasury takes care of that. But it's the executive branch of the government that's doing revenue rulings and revenue procedures. And then the judicial branch is responsible for court decisions. So whenever a taxpayer, which is you, me, have a problem with something that the other two branches have come up with, who do we go to? We go to the courts. And the courts are the ones that determine tax law when the taxpayer and the government, the rest of our government, really cannot agree. Okay? Sometimes you have cases that are undecided, like we discussed yesterday. Sometimes you will have one circuit court that says one thing, and sometimes you will have another circuit court that says another thing. The courts don't always agree on exactly the same issue. The Supreme Court is the only court where the IRS actually has to acquiesce to the decision. They can choose to disregard other decisions, and many times they do. Okay? The courts will say, we believe this, the taxpayer's in the right, blah, 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 blah. And the IRS will say, we're pretty happy with our position and we're just going to keep it. And they will do that until the Supreme Court sometimes tells them no. Sometimes they will agree and sometimes they won't. Okay, there's multiple types of IRS guidance. Remember, the IRS is the collection arm for the U.S. Treasury. That's their job. The IRS's job is to collect revenue from taxpayers and from entities. That's what they do. The U.S. Treasury Department is responsible for paying government expenses. So money flows in and money flows out. All right? The IRS takes the specifics of the laws enacted by Congress and translates them into documents that taxpayers use for guidance. And sometimes when you're reading the actual code, the IRC, it does seem like a foreign language. You know, the code is like a tangle, and henceforth, and be with, or whatever. So when you actually go in and read the code, which I do frequently, there are times when, because it'll be the law, and then there'll be one exception, and then another exception, and then another exception, and then another exception. So you have to like go layers and layers and layers and layers down to find the answer that you're looking for, and sometimes even then it's not clear. All right. So you have Treasury regulations, and these are in levels of authority, like which one is the most important and which one is the least important, going down, down, down. Okay, so Treasury regulations are number 1, all right? Revenue rulings is number 2. Revenue procedures, number 3. Private letter rulings are not supposed to be precedential, which means a private letter ruling is one taxpayer with a question. And they send that question to the Internal Revenue Service. These didn't used to be public, and then the attorneys fought for them to be released to the public, and now everybody can see them. You can go online and you can see them. And there are companies that they make like CDs, or you can have like a subscription online where you can search. So a lot of times when you're getting into rep work, this is very helpful to have, because the IRS is never going to give you the information that you need to fight for your client's case. Does that make sense? You have to fight for your client's case. They're never going to like hand it to you and go, hey, we were in the wrong here. That's never going to happen. So a private letter ruling is not supposed to be precedential, but we can use a private letter ruling for our guidance if we have a taxpayer that has a similar issue, okay? For example, there are multiple private letter rulings out there where somebody wants to deduct moving expenses, okay? Or somebody is requesting a Section 121 exchange. They want to exclude the income from their home. And for whatever reason, they have a delay or a specific thing and they want to ask if perhaps an unforeseen circumstance would qualify. And then maybe you have a client that has the same situation. It's not in the pubs, it's not in the code, but you're going to use it as your example in your tax case. Okay? Technical advice memoranda. Now this is the opposite of a private letter ruling. This is when the Internal Revenue Service itself has perhaps multiple taxpayers that keep coming up with the same question, okay, the same question, and the examination division usually will request guidance from the IRS Office of Chief Counsel. We keep having this taxpayer issue come up, and we need to know what to do. We don't know what to do. And so the IRS will issue a technical advice memorandum to give guidance to the Internal Revenue Service and also taxpayers on this, on the particular issue that they're asking about. And then you have IRS notices, which is number 6. Each of these has substantial authority in order, which means it can serve as authority for the basis of interpretation of current tax law and establish precedents for the future. Okay. So this is all guidance that we can use while we're doing our job, and you will. In practice, we do this all the time. When you do rep work, it's very important. Okay, Treasury regulations. Treasury regulations are kind of the top of the list when it comes to IRS guidance. Okay, this is the U.S. Treasury Department's official interpretation of the Internal Revenue Code. Okay, this is, Congress will pass a law, and then the U.S. Treasury Department will come out with a Treasury regulation that says, this is what we think Congress's intent was, and this is our position. Okay. The Internal Revenue Code authorizes the Secretary of the Treasury to prescribe all needful rules and regulations for enforcement of the code. So the IRS also is not just the collection arm, but also the enforcement arm, okay, of the U.S. Treasury Department. All Treasury regulations are written by the IRS Office of Chief Counsel and approved by the Treasury Secretary. So these are all like IRS attorneys that are, I don't know how big the IRS Office of Chief Counsel is, but they're very influential, obviously. The courts will give weight to Treasury regulations and will generally uphold them, okay? As long as the IRS's interpretation is reasonable, or of course this is the area where we can fight, right? We don't believe that this is reasonable. Or as long as the Treasury regulation does not contradict any other provisions that are actually in the code. You can also fight and have them overturned on the basis of a Treasury regulation being unconstitutional, which is what happened in the DOMA case. Remember, the IRS is bound by its own regulations. Once a Treasury regulation is out there in the wild, the IRS employees are bound by them. They are bound to follow them. But the courts are not bound by Treasury regulations. The fact that the courts will give weight to Treasury regulations doesn't mean that they have to follow them, and they frequently do not. Okay? The IRS doesn't like this, but the U.S. court is a completely separate branch of our government, and they are not obligated to follow any type of administrative interpretation that the IRS has come up with. Okay? All right. And we're going to go over a case later where if you read the case, you can sense that the IRS attorneys are super pissed off that the courts have come up with the decision that they've come up with, and they're saying that the court is basically creating its own law, which the courts are not. Courts do not create law; they decide on law. But there are some judges that kind of do what they want, right? There's a lot of interesting cases out there, and I do kind of read them for fun. I enjoy it. Okay, 3 types of Treasury regulations are legislative, interpretive, and procedural, and it's kind of exactly what it sounds like. Legislative regulations are created when Congress delegates the authority of the Treasury Secretary to provide requirements for a specific provision, okay? They're generally not overturned, but they can be if it is outside the power delegated to the U.S. Treasury. That's the whole argument of the Loving case. Remember the Registered Tax Return Preparer exam? Remember that? And the IRS was trying to make that mandatory, and they were going to make it mandatory. And then the Loving case was when a couple of tax preparers got together. Loving is the name of one of the tax preparers that came up. The Loving case was landmark for all of us as tax professionals. This was a situation where they said, you don't have this authority. The IRS does not have the authority to regulate tax professionals. Okay? The IRS said, yes, we do. And the preparers said, no, you don't. And they went to court. And the IRS lost. So in that case, the courts agreed that the IRS interpretation was wrong. They do not have the authority to regulate tax professionals. Okay? We're going to talk about another case that's really important. And Circular 230 has not been updated yet. And it's the issue of contingent fee arrangements. They lost on that one too. The regulation can be overturned, again, if it conflicts with a specific statute or if it is deemed unreasonable by the courts. If the courts say this is unreasonable, then they can overturn it. Interpretive regulations only explain the meaning of a portion of the code. And unlike legislative regulation, there's no grant of authority for this. They can be challenged in court. And a procedural regulation is usually a minor issue. Procedures, right? Where they say, the notices have to be sent to the employees by this day. You have to mail out W-2s by this day. That sort of thing. So this is minor issues down here, and this is a big deal up here, right? So it goes in order of importance. Okay, case law. So case law is not the Internal Revenue Code. This is when the courts have made decisions on tax law. There are many instances where tax laws are disputed or overturned. Many, many instances. Court decisions then serve as a guidance for future tax decisions, and they also serve as guidance for us. Okay? If there is a court decision in our client's favor, even though it is contrary to the IRS position, that is a situation where you, as a tax professional with your client, have to come to a decision on what type of tax return you're going to be filing. You know what I'm saying? We can talk about a couple of those. In most instances, the court will choose whether or not to acquiesce or non-acquiesce. And in prior exams, the question that they asked was, which is the only court that the IRS cannot non-acquiesce to, or which court must they follow? And it's the Supreme Court, not the tax court. That kind of confuses people sometimes. The IRS is not compelled to acquiesce to any tax court decision. They don't like losing, but they're not forced to acquiesce to any of those rulings. The IRS is not bound to change its regulations due to a loss in court. The only exception is the U.S. Supreme Court, whose decisions the IRS is obligated to follow. The IRS does not announce acquiescence or non-acquiescence in every case. Sometimes they will have no comment, and they'll just let it sit out there, like, tempting everybody, but they won't tell us what their opinion is on the matter. Apparently this, from what I hear from attorneys, we do have one attorney who is our co-author who's very, very good, Joel Bush. I have heard from multiple attorneys that the reason why the reason why the IRS won't come out with specific comments sometimes is because they will lose a case on the West Coast, right? And they know that maybe the whole Western United States, now the tax preparers are going to start using that case for taking a specific position on a tax return. But all the IRS campuses on the East Coast will continue to pursue the IRS position, the existing IRS position. And they do that because they know that most taxpayers are not going to take their argument all the way to the court. Do you understand what I'm saying? Most people will stop at appeals. And it's like 97% of the cases are solved in appeals. They don't go to the tax court. A lot of times the IRS will actually concede in appeals because they don't want the case to go public. Do you understand what I'm saying? Because they know that 90% of the taxpayers that they hit with whatever position they are arguing are just going to lay down and pay the bill, right? So there is an absolute reason why they don't do this, why they kind of keep quiet sometimes. Freedom of Information Act requests. I've done this twice. One I was successful, the other one I was not. A Freedom of Information Act request is a law designed to ensure public access to U.S. government records. You make a formal request. The IRS can withhold under certain exceptions, okay? They have 20 days to say whether or it will comply with the FOI request. That doesn't mean they got to give you the documents, but they have 20 days to tell you whether you will comply. The two cases that I had, when the request is denied, the IRS must give a reason for denial and explain the right to appeal. So there's a whole procedure for that, but of course the IRS doesn't really like these, so there's no actual form. You've got to send them a letter. And I had two cases. One was a case where the IRS was claiming that they didn't receive a tax return. Of course, it was a situation where the taxpayer, I had told them, I always tell them do certified mail, do certified mail, do certified mail. And a lot of times the people will not listen because they don't want to spend the $5. Right? She's like, she knows. Because they don't want to spend the $5 on the certified mail. So they just stick it in the thing and then they get a penalty for late filing. Right? In this case, it was a couple $1,000 because it was a lot of money. The taxpayer came to us and he goes, I mailed it like a couple of days before. I actually mailed it on time. And of course I said, did you send a certified mail? And he goes, no, I just put a stamp on it. So I said, okay. The thing is that the IRS doesn't know. A lot of times the right hand doesn't know what the left hand is doing. You know what I mean? It's like a bureaucratic spaghetti bowl of craziness, right? So if you have a division that is sending you a letter for late filing penalties because the return wasn't received on time, there's a good chance that if you submit a Freedom of Information Act request, it's not going to be the same division that's sending you a letter. So they don't know specifically why you're asking for those documents. So what I did is I asked for a complete copy of the return and a complete copy of the taxpayer's file. It came, and of course the postmarked envelope was in the stack of junk that they sent me. It was like a big long stack. And they sent me everything, and they keep the envelopes. When I was working for the state of California, it was like that too. When you work in AP, they want you to keep the envelope as well as the bill, the copy of the bill. It's like paper, stuck to the nines. You'd think they'd get with the program, but they don't keep scans of anything. But yeah, so I got the stack of papers, and I had the letter in there. And of course, my response to the next notice was, perhaps, I'm never rude, right? Because that you're going to lose. You know, they can really make your life difficult. I'm never rude. I go, perhaps this was overlooked when this bill was sent out. So we are providing you a copy of the envelope. This is the taxpayer's proof that the tax return was mailed on time. And then the matter was dropped. So in that case, I won, right? So you can request the Freedom of Information Act for anything, really. And sometimes the IRS will comply and sometimes they won't. Okay? All right, the Taxpayer Bill of Rights. So they will get, whenever you go into an examination, they have to hand you like the Taxpayer Bill of Rights. It's a pub. And the taxpayer has a right to be informed. A lot of this seems just like, they're blowing smoke in our direction, right? They have a right to quality service. Like one of those, oil change places. They had quality service. The right to pay no more than the correct amount of tax. They don't seem to follow that Bill of Rights that particular one, that closely. The right to challenge the IRS's position and be heard. The right to appeal. The right to finality. The right to privacy. They're pretty obsessive about that. The right to confidentiality. The right to retain representation. And the right to a fair and just tax system. Taxpayer advocate. This is the TAS. The TAS used to be very useful to me. But kind of, I would say, maybe around the year 2010, 2011, I felt like the Taxpayer Advocate Service was kind of losing its teeth. They're either completely overwhelmed, or the IRS is giving them less and less and less and less authority to help. The Taxpayer Advocate is supposed to be, is independent. It's not supposed to be. It's an independent agency outside of the IRS, but still part of the Department of the U.S. Treasury. And the Taxpayer Advocate is who you go to when you have, run circles around the IRS issue and then you can't get any help. If you have a taxpayer who's going to have significant economic harm or significant delays in resolving a tax issue, usually I will contact them, and if I have an amended return that's taken more than a year for them to give me any kind of stuff, because a lot of times you'll have an amended return. I had one with an identity theft issue, and once you've got an identity theft issue, it's like a nightmare trying to get it resolved. We had one taxpayer where it was an identity theft issue. We filed the identity theft affidavit, and it was even worse because it was a joint tax return, but only her identity had been stolen. So, the husband and wife were together and they filed jointly, but not until very late in the year. They were on extension. And some scammer had taken the wife's social security number and filed a single return and e-filed it and gotten a huge direct deposit refund off of some fake numbers that they had invented, in January. And then 10 months later in October, we're filing her return and we're getting a reject that a return had already been filed for her. So October 2014, she and her husband file. We have to file on paper because you can't e-file anymore because you're getting a reject that there's already a return out there. And then we start getting all these notices for that fake return for the wife. Okay? We feel like you've made an error. It was filed as single. She's not single. And so finally, we had to get the Taxpayer Advocate office involved, but it's like a year of waiting. And she had she and her husband had a legitimate $6,000 or $7,000 refund from the joint return, but 9 or 10 months later, they still hadn't received it. Because the IRS had already paid out on the fake return, right? So it causes a lot of problems. The form where you request assistance is Form 911. I'm not joking. It really is 911. So that's a very easy form to remember. So when you're in very bad shape, that's who you call. The good thing about the Taxpayer Advocate Service, and they absolutely can do this, is they will put a stop to collection activity for you. They will put a stop to collection activity for you. They will give you time, whatever the issue is, whether the taxpayer owes money or doesn't owe money because of whatever is going on, they will put a hold on the account for you so that you can try to figure stuff out. So that is very helpful. And sometimes they'll pause it. They'll pause collection activity for 60 days just so you can get a breath and request the information and everything. So that's very helpful. So you should always remember the Taxpayer Advocate Service is out there to help. Okay, Unit 2. So let's go into practice before the IRS. Practice before the IRS has changed what actually constitutes practice. And practice before the IRS has changed because of the Loving case. Okay? The IRS wanted to say that practice before the IRS includes the preparation of tax returns. They wanted to say that because then they could regulate tax preparers who were preparing returns. They lost the Loving case, so now preparation of tax returns does not constitute practice before the IRS. The problem is that Circular 230 has not been updated yet. The IRS is very upset about all of these losses, not just Loving, but the Ridgely case, which was the contingent fee case. They lost that one too, and Circular 230 has not been updated yet. So we always tell people who are taking Part 3, you got to read Circular 230. It's not a very long publication, but you got to read Circular 230. Like for Part 1, you read Pub 17. Got to read Pub 17. And for Part 3, you got to read Circular 230. The problem with this here is that Circular 230 is not correct in many areas because the IRS has lost multiple cases that affect Circular 230. So the only advice that I can give you is proceed with caution, okay? I do not know if the IRS is going to stick to its guns about some of these things because their public comment doesn't seem to be like they're backing down. Do you know what I mean? They're not happy about any of this stuff. So the Loving case and the Ridgely case happened like in 2014, 2015. So these are kind of like real recent cases because the IRS appealed Loving and they lost the appeal too. Okay. However, at this time, practice before the IRS includes corresponding and communicating with the IRS. If you are not an enrolled practitioner, or if you do not have if you're not one of the other exemptions, like a close family member, the IRS is going to toss your correspondence in the trash. They're super pissed about this whole thing. And before this Loving case became a fiasco, I remember that the IRS used to at least talk to you if you were a third party and you weren't an enrolled practitioner. And now they don't even do that. They make it really hard for you to do your business unless you have at least an enrolled practitioner in the office. And that's intentional. They're real not happy about it. You cannot represent a taxpayer at any type of conference, hearing, or meeting with the IRS. There's a narrow exception to that, but the taxpayer has to be present, which is never good. You cannot prepare and file certain documents with the IRS. The Circular 230 still says documents, just in general. Obviously, tax returns isn't included in that anymore, but if you are like responding to a notice, the IRS isn't going to take your response, right? Or they don't have to. If you provide written advice that has potential for tax avoidance or tax evasion, that's like tax shelter advice. Only attorneys do that. Only attorneys like take that kind of a risk. I'm assuming that there might be one crazy enrolled agent out here in the United States that will put their name on something like that. But this is tax shelter advice is a very specific type of advice that is just about tax shelter activities, and there is huge risk attached to it. Okay, the only people that do that kind of work these days are like attorneys. Incidentally, U.S. citizenship is not required to practice before the IRS. You can be an enrolled agent or even a CPA overseas, and many of them do have overseas clients. There's tons of expats living outside the U.S., and there's also, foreign persons who are not U.S. residents, but they own tons of U.S. investments, and they still have to file a U.S. tax return. I just found out, I guess I watch the news kind of obsessively, and in the Middle East, the Saudi government or royal family or whatever, they own tons of U.S. treasuries. I mean, like billions with a B. So there was one point they're kind of like this U.S. government and the Saudi government is kind of playing chicken, like if you do this, then we're going to dump our U.S. treasuries. And you don't want that. You don't want one person or one investor to dump like 1 billion U.S. treasuries on the market in one day. That would be bad. Anyway, so U.S. citizenship is not required. You don't have to be a U.S. citizen or a U.S. resident. However, and you can get a PTIN if you're a foreign preparer. The thing that you cannot get is an EFIN. So people who are foreign preparers cannot get an EFIN. They cannot electronically file returns. So if you actually look on the IRS, there's a form for when you can't e-file or when you don't e-file. There's actually a specific line just for them that says, I'm a foreign preparer and I am not eligible for an EFIN, so I cannot e-file. Yeah, so that's the rule. They can get a PTIN, but no EFIN. Okay, the Loving case. In a significant loss for the IRS, the U.S. Court of Appeals for the District of Columbia, and when I say District of Columbia, I have had a class at one point where they thought I was talking about Columbia, the country. No, the District of Columbia is like the seat of the U.S. government. And it's, they upheld a lower court's decision, so this was on appeal, that the IRS does not possess legal authority to regulate tax return preparers when it created the Registered Tax Return Preparer program. I took this exam. I felt like it was relatively easy. It was open book. If for any of you that attempted it, it was open book. You were allowed to you were allowed to see Pub 17, and you were allowed to look at a 1040, a Form 1040. So I felt like it was rather simple. As a good minimum to see like if the person should be preparing tax returns. I never felt like it was a big deal. I don't know why these tax preparers were so against it. But because of this case, it means that tax return preparation in and of itself does not constitute practice before the IRS under current law. Circular 230 has not been updated to include all this information, and Circular 230 does not include that new voluntary AFSP regime that the IRS has come up with. This is an annual filing season program certificate, blah, 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 where you take an annual refresher course and then you get a certificate that's designed to replace the now defunct Registered Tax Return Preparer program. All right. Enrolled practitioners. These are the individuals who can represent taxpayers before the IRS. If you're an EA, it doesn't matter if you prepared the return in question. It doesn't matter if you, if the person does not have to be present at the examination, and you can represent a taxpayer with every level of the IRS. You can represent them with appeals, with collections, with examination. You can do all of that. And the taxpayer never has to be involved. Okay? So attorneys, certified public accountants, and enrolled agents are the only ones that are allowed to do this. They have unlimited practice rights. Enrolled actuaries and enrolled retirement plan agents have limited practice rights. What you see most of, enrolled retirement plan agents don't generally prepare tax returns per se. They prepare tax returns for employee retirement plans. That's the whole business in and itself. So what happens is they will come in and they will represent the retirement plan when they have to file the Form 5500. All right. So they have limited practice rights, but generally it's just going to be governing retirement plans. Okay, the annual filing season program. I don't know if you're going to get questions on this, but I did hear that when the Registered Tax Return Preparer program was in effect, the EA exam did test a little bit on that. So you might see something about this and you might not. It's not in Circular 230 yet because it's kind of a new thing. The IRS kind of slapped this together once they removed the Registered Tax Return Preparer program, which I don't know why they went this route, because in the Loving case, the judge said two things. The judge in the Loving case said, you can require tax preparers to have a PTIN, which the IRS does. So they said that's not the regulation of tax preparers. That's an identifying number, and you can force tax preparers to require a PTIN. You can also make the Registered Tax Return Preparer program voluntary. They didn't. They could have made it voluntary, and they could have created a situation like we have in California where you can actually say, I'm a C-Tech, which is nice. Preparers like that. But they didn't. They decided to create a completely new program, which is the annual filing season program, and it's also voluntary, and this was created in like the middle of the year in 2014. All right? And this was something that came out like a month after they lost the appeal. So they came up with this real quick. To receive a record of completion, they're very obsessed with this particular verbiage, record of completion. They don't want you to say certificate. They don't want you to say certified. They don't want you to say any of that. It's to obtain a record of completion. The person has to have a minimum of 11 hours. I don't know why they picked that odd number, 11. 11 hours of continuing CPE, and those 11 hours have to include a 6-hour refresher course. So it's 11 hours of whatever else, and then a mandatory 6-hour course. You have to pass a test that is administered by the CPE provider, not by the IRS. The Registered Tax Return Preparer program, the test was administered by the IRS, and that's not the case anymore. Now they're just letting the CPE providers do it. You have to have a PTIN, and you have to consent to the duties and restrictions relating to practice before the IRS. Now here's the IRS's back door. To get that record of completion, right, you have to consent to this, and this consent gives the IRS authority to regulate you. Got it? So in order to get that and be called an annual filing season preparer or whatever, you have to sign a consent that gives the IRS the consent to regulate you. Does that make sense? Preparers who do not participate in this program, who are not enrolled agents, are not going to have zero practice rights, number one. And number two, they don't get listed on the IRS's new Check Your Preparer website thing. So the IRS has a new area on their website where you can look up a preparer by name. You can look up your own name on there too. You can look up a preparer by name and the city, right? And it'll pop up and it'll tell you whether the preparer has a current license or not. You can opt out of that, which I did. I don't want to be on their thing because I get enough junk mail as it is. You've noticed that, right? If you give them there was a Freedom of Information Act request at one point, a couple years back, where all of these like junk CPE companies wanted to get people's PTIN information, and I stupidly put my email on there, and it's like I can't even count the number of junky like CPE emails that I receive every week. I keep like marking them as spam and opting out of all of these newsletters, and I still get them. And I just found out like last year that you could opt out of that and take all of your information off of the PTIN thing, which I did, but it's already too late. My email is out there, and I'm never gonna be able to get it back. So much junk. Okay, unenrolled tax return preparers. Now, before these two regimes came up, anybody who wasn't an enrolled agent, CPA, or attorney, the IRS would just call them unenrolled return preparers. Anybody who doesn't have a license is just unenrolled. Okay? In general, unenrolled preparers only have limited practice rights before the Internal Revenue Service. Starting with tax year 2015, which is the tax year that we are in, as soon as December rolled around, this became the law. Only unenrolled tax return preparers who have current AFSP certificates may represent taxpayers during an IRS examination. And they can only represent them in the taxable year period covered by the tax return or claim that they themselves prepared. So if you are an unenrolled preparer and you prepare my tax return for 2015, if I get a notice, you can represent me in the examination division only for the tax return in question that you prepared, right? And if I end up having to go to the IRS office, I have to be there. Okay? If you are an unenrolled preparer who does not participate in this program, which is voluntary, you do not have to do it, then you have 0 practice rights. You can only prepare tax returns and that's it. Okay? This is the fallout from the Loving case. The funny thing is I wonder, so all of the people that went out for the Loving case were, I'm assuming they're unenrolled preparers, which is the reason why they were arguing this in the first place. So if they're unenrolled preparers and they were previously kind of involved in rep work, doing rep work, I mean, if they had practices, then they're going to have to do a small amount of it no matter what they do. I'm wondering, like, now they're stuck with this. So the situation isn't any better if they want to do, you know what I mean? It's not any better. Now the IRS won't talk to you at all. And they've created this new thing where taxpayers can go up and search for you, and if you're not on the list, then then the whole implication is that you're not licensed, you know? Anyway, I don't think that they're better off. All right, now you have to remember that there are exceptions to this. You can have limited practice due to a special relationship. So these are unenrolled people, okay, who are allowed to represent taxpayers fully. They have full representation rights in limited circumstances, okay? So an individual can always represent themselves, right? That makes sense. A family member can represent members of his immediate family. And that is how I started representing people, was when I was just a little C-Tech here in California, and I was like a babe in the woods. My first rep case was a family member. And even though I was only a little C-Tech and I was not an enrolled agent yet, I put all my little information on the thing. You know, the first time you fill one of these out, it's a little bit exciting. You know, your heart beats a little bit. So it's the form has changed a little bit. You put the taxpayer's name and address. In this case, it was my family member would go up here. My family member's social. For daytime phone number, you never put their number. You always put yours, right? You don't put theirs because you don't want the IRS calling them. So their daytime phone number is going to be my daytime phone number because I am their rep. That's what I always do. If the plan number is if it's an entity. Name and address, okay? And the name and address is the name and address for me. That's my name and address. And just so you guys know, this used to be just 3 lines, and now it's 4. You can never put the name and address of an entity down here. It has to be a human. So like I couldn't put, you know, PassKey tax service. Because this authority cannot be delegated to an entity. It has to be a person. So that's one place where, like, when people are first starting out, they mistake. You can't say, you know, Simran's tax service on this line. It has to be a person. Okay? And then under CAF number, if you do not have a CAF number, and this is the first time you are filing one of these, you put none under CAF number. And then they send you a CAF. And then you put your PTIN, your telephone number, your fax number, and then that's it. Okay, that's how you get it. And the line for family member is right here. I am one of the following, and you put F. That's your designation. Okay, that's it. And you don't have a license number yet, right? But you just sign and date. You got to make sure the taxpayer sign and date. Oh, for God's sake, make sure that the dates match, because the IRS will. They don't like it. You can't have a date that's like a month behind when you know what I'm saying? You got to be signing at the same time. Otherwise they will tank it, and I've had that happen before. So I just make sure that the dates are the same. Like as if I signed it and you signed it on the same day. An officer of a corporation can represent a corporation even if they're not a shareholder. Notice it doesn't say shareholder. It says officer. So if I have an officer of a corp who is not a shareholder of the corp, they can still represent the corp if I do not want to represent the corporation. A partner in a general partnership, a general partner can represent a partnership. Remember that though, this is a very common question on the EA exam. A limited partner cannot represent a partnership, only a general partner. Of course that makes sense. A limited partner doesn't have risk of loss. They only have risk of loss of their investment. A full-time employee can represent an employer. I've done this before also as a bookkeeper for a business. If you're a bookkeeper, a full-time bookkeeper, you can represent the business. And that's pretty common if the bookkeeper is doing payroll tax returns. So what ends up happening is maybe the IRS will have a question, or they're saying the payroll tax returns weren't filed properly, or blah, 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 blah. And the full-time bookkeeper will be the one dealing with it because the owner doesn't know any of that stuff. So in that case, an employee can represent a business, their own business that they work for. A fiduciary is a trustee, executor, personal representative, receiver, or guardian of an entity. And it's weird because the way that the law works is that a fiduciary of an estate, the person is dead. So the fiduciary is kind of considered to be the taxpayer and not a representative of the taxpayer because the taxpayer is deceased. So the fiduciary kind of steps in and they're not actually considered a rep of another person because they're not. So they're representing the entity. And there's also an authorization for special appearances, which is, I don't know of any cases where this has happened, but it's in Circular 230. In rare circumstances, the commissioner of the IRS or a delegate will authorize a person who is not otherwise eligible to practice before the IRS to represent another person for a particular matter. The request is made to the Office of Professional Responsibility. If granted, the written consent will detail specific circumstances related to the appearance. I do think that there might be a situation where maybe you have a member of the military that doesn't have any family, and maybe their like commanding officer could represent them. They're not on this list. They're not a family member, right? So I have heard that sometimes like a commanding officer will step in to be involved when maybe you have a military person that doesn't have anybody else to step in for them, all right? Like, especially if you have a situation where maybe a person is overseas and they're unmarried and maybe the only other family they have is a minor child. So in that case, there's no appropriate representation for that person, right? A girlfriend can't represent her boyfriend. Do you understand what I'm saying? They might be together for years and years and have children together, but that girlfriend can't represent the taxpayer. Wife can. Husband and wife, they're considered close family. But like an unmarried couple, they cannot. Okay, ineligible to practice. Once again, an entity can't practice before the IRS, so you can't put your practice name on there. It has to be only individuals, humans. Even if named in power of attorney, an individual will not be recognized if they have lost his eligibility to practice before the IRS. Apparently this is a pretty common thing, where you'll have an enrolled agent where they've been stripped of their status, and attorneys get stripped of their status real often for whatever cockamamie thing they're doing. CPAs do too. And they will continue to try to run their business even after they've been stripped of their license. They can get slapped for this, but the IRS is supposed to not recognize their power of attorney if they've lost their eligibility to practice. It could be for an unrelated thing too. If you have an attorney who gets stripped of their license because they've committed a different type of felony that's not even related to the IRS, regardless of the fact that it's not tax related, if they're stripped of their license at the state level, they can no longer practice before the IRS at the federal level. That's it. Reasons for losing eligibility include suspension or disbarment, placed in inactive retirement status. Sometimes enrolled agents will do this voluntarily. They will ask to be placed in inactive status. and not meeting the requirements for renewal of enrollment, such as fulfilling their continuing education requirements. That's actually pretty common too, although not so common anymore, because now the CPE providers report the hours. Okay, and you got to keep your certificate, because on more than one occasion I've taken CPE where maybe I put the pig tin wrong, or they got my name wrong because my name's a little unusual, and they don't call you up and say I can't submit your hours. They just leave it out there, and you have to have the certificate as proof. So keep your certificates is what I'm saying. You got to keep them at least 3 years. You don't want this to come back and bite you. Actions that are not practiced before the IRS. Okay. Practice before the IRS does not include representation of taxpayers before the U.S. Tax Court. The U.S. Tax Court is separate. It has its own rules of practice. And if you're an enrolled agent or a CPA, you cannot represent taxpayers before the tax court unless you take and pass the U.S. Tax Court exam. Attorneys who have an active license do not have to take that. Obviously, they're already attorneys, and they can represent taxpayers before the U.S. Tax Court with any other special licensing outside of their regular attorney licensing. You can appear as a witness for the taxpayer. This is also, if you are an unenrolled preparer, I looked this up specifically. If you're an unenrolled preparer and you are a non-enrolled agent or whatever, and you have a taxpayer that goes to appeals, you cannot represent taxpayers before appeals, but you can appear as a witness. I don't know, I've never had a situation like that. I never went to appeals without being an enrolled practitioner, so I don't know how that actually works. Maybe you sit down and you have to be quiet until they ask you to speak. Or maybe you're allowed to have conversations as long as the taxpayer concedes, right? I don't know how that actually works in practice. They can't advocate for the taxpayer though, like we can. After the IRS's most recent loss in court, the preparation of tax returns is not considered practice before the IRS. Okay, TIGTA, am I saying it right? TIGTA. TIGTA is very, very important. That's the Treasury Inspector General for Tax Administration. They issue reports every year with all of this scary stuff in it. So every year they'll issue a report about PTIN compliance, about what the IRS is doing wrong. They're completely independent. This is part of the Department of the U.S. Treasury. And you should, if you have a situation where you see some unethical behavior at the IRS level, you can actually say, I'm going to report you to TIGTA. And that's very scary to them. They don't like that. So the Treasury Inspector General is completely independent of the IRS. Sometimes they will say good things about the IRS, sometimes they will say bad things, but they say what they want, is what I'm saying. In August 2015, which is very recent, just a couple months ago, they issued a report, and all the reports are public. You can read them. Okay. Whenever they issue a report, there's always this flurry on Forbes.com and everything else where they TIGTA just issued a report. So there's lots of news that comes out. The most recent one is about PTIN compliance and suggestions for what the IRS can do about PTIN enforcement. Apparently, TIGTA gave them like kind of a side dig that said, look, you guys are whining and crying about losing the ability to regulate tax professionals, but you never lost the ability to regulate the PTINs, right? There's a lot of tax professionals out there who are not compliant with their own tax filing obligations, but you still let them have a PTIN. Why don't you do your job and pull their PTINs and pull their EFINs? So that was the most recent report. They said, why are you still letting them have a PTIN? Why don't you work with what you've got? Okay? And the IRS usually goes, we're working on it. Right? They'll respond, they don't like it. So TIGTA usually comes up with very common sense solutions to whatever problem the IRS is working with. I feel like this is a very common sense solution. If you have a bunch of tax professionals and they have a PTIN and they haven't filed their own personal returns, they're doing other shady stuff, pull their PTIN. TIGDA reports that there are about 7,000 preparers with P10s, 700,000, I'm sorry, it's almost a million, 700,000 preparers with P10s, and about 406,000 P10 holders, or about 58% are unlicensed professionals. I felt like that number was really high. I do, I feel like that's really high. About 58,000 P10 holders are enrolled agents. Sometimes this number, I've seen this number up to 70.
I think nationally there are only like, maybe they include the retired, there are only like 130,000 EAs across the country.
That's possible. That's possible. But about 50,000 P10 holders are enrolled agents, and the rest, about 240,000, are other licensed professionals like CPAs, IRPAs, and attorneys.
That's all we've got
That's all we've got.
for P10s?
Yeah,
I mean, you have to use a P10.
you have to use a P10. However, everybody has to use a P10. The only exception to that is like an employee that doesn't sign tax returns and who doesn't do any, but most of the time they gotta have one too. I felt like this was kind of
So
low.
700,000 preparers with P10s, okay, 700
Yeah,
plus 50, I know that number should be doubled, let's say 100, that's 800,000. And then,
That's it.
then another, and then, so there's about a million four, including the CPAs, and then about 500,000 unlicensed.
yeah. This is the most recent report. I swear that in the past this number has been higher. I felt like it's been higher.
Yes, I think it's about 100,000.
Yeah, I've seen it as high as like 77, 80, 90. I don't know why it's so low now. I don't know, maybe the EAs are kind of dropping off because they're not doing their CPE, right? Or whatever. IRS P10 requirements. Under Circular 230, the IRS requires that all paid tax return preparers must register with the IRS and obtain a P10. I know that there's probably shady tax preparers out there that are not doing this, right? They're taking cash, they're doing shady stuff, and they're not putting the P10 on the tax return. Even if I do a pro bono return, I always use my P10 on the return, okay? I do. Tax preparers who register for a P10 must undergo a limited tax compliance check. They have to be up to date with their own personal and business tax returns. The use of a P10 is now mandatory on all federal tax returns. Didn't used to be, but it is now. And the P10 requirements applies to all enrolled agents. Attorneys and CPAs don't have to obtain P10s if they do not prepare tax returns. So there are CPAs that only do audit work and they never do tax. In that case, they don't have to request a P10. Attorneys, obviously there are attorneys that never prepare a tax return either. They just do criminal law or whatever. And in that case, they don't have to obtain a P10 either. Okay, so that's where the P10 goes. You guys know on the Form 1040, which is right here, it's on page 2. It's right here in this little corner, this tiny little corner that doesn't even look like there's enough space. But it's right here. We're right next to the thing that says check if self-employed. Okay? And that's where the P10 goes. Okay. Supervised preparers are also required to have P10s. These are individuals who don't sign tax returns, but are employed by enrolled practitioners. Okay? If you have employees in your office and you are an EA, CPA, or an attorney, even though these people are not signing the tax returns, they still have to have a P10. Even if it's your P10 that's actually going on the return after you review the returns, right? They still got to have a P10. Supervised preparers cannot sign any tax return they prepare and assist in preparing, represent taxpayers before the IRS in any capacity, or identify themselves as Circular 230 practitioners. Now, since the Loving case, this is what it still says in Circular 230. Since the Loving case happened, I don't think that the IRS is allowed to say this anymore, right? There's a whole class of supervised preparers out there that are kind of blowing in the wind. I don't think that the IRS can regulate this. However, it is still in Circular 230. So I'm telling you this now.
Do they have a requirement for like continuing education or?
No.
So other than obtaining a P10,
P10, that's it.
That's it.
Yes.
Okay.
The IRS fought that and they lost, right? So, supervised preparers, the IRS is still saying that supervised preparers have to have PTINs, but I don't know if any of this stuff is still valid, right? Regardless, the IRS is kind of sticking to their guns about the AFSP thing. So if you have a supervised preparer that wants to help you represent taxpayers in any capacity, you got to have them do the AFSP program. But if you're the one running the show, and the supervised preparers may be just preparing the return and you review it afterwards, I don't think that the IRS can even regulate that. The only thing that they can do is require that supervised preparer to have a PTIN. All right? Okay. Exceptions. There are exceptions to the PTIN requirement. This is a kind of a thing because I had a tax colleague, a CPA, ask me about this. A paid preparer for Circular 230 preparer penalties is someone who prepares a return for compensation. If you are like a CPA or enrolled agent and you don't prepare tax returns anymore, except like for family where you don't charge them, let's say you do like 10 returns a year, you don't charge these people, you are not a preparer, okay? You're not a preparer, period. None of these rules are going to apply to you. However, the agreement for compensation is what triggers this requirement, not the fact that the person paid you or didn't pay you. So if the thing that they asked me is, I have a client. They came in and I prepared their tax return and I sent them a bill and they did not pay me. Okay? The client later gets in trouble for whatever, they were lying about their earned income credit. The 2 kids on the return weren't there, so they were not the custodian or whatever. The preparer wants to know, am I a preparer on the tax return for preparer penalties? Do I have a liability here? And the answer is yes. Even though the person did not pay you, you had an agreement for compensation. So Circular 230 doesn't actually say that you have to receive the payment. The contractual agreement for compensation is the deciding factor. And you can actually look that up in Circular 230. I looked up the verbiage. So that's the deciding factor to whether the IRS considers an individual a tax return preparer on a particular return. Got it? It's the agreement for compensation. So this is very different than going into an engagement with the intent of it being pro bono from the very beginning. All right? An individual is not considered an income tax return preparer and would not be required to get a PTIN in the following instances. A person who just gives an opinion about events that have not yet happened. So if you give tax advice to your neighbor, okay, you guys might be laughing a little bit, but this has actually happened and it became a case, right? It's like, you remember that show Home Improvement where Wilson is like the neighbor like this over the fence? They had a neighbor who had an enrolled agent who was a neighbor, right? So they were neighbors. The one neighbor asked for advice over the fence about what he should do about a business. You know, sometimes it's like playing telephone and the person only hears what they want to hear, right? The enrolled agent gave him advice, which was either incorrect or the taxpayer wasn't listening correctly. And I think it was an employee misclassification issue. The neighbor over the fence tried to go after the enrolled agent for giving him bad tax advice. In that case, the preparer was not liable because they gave tax advice for a business that had not been created. He was just asking, can I do this? And the enrolled agent probably said, maybe, blah, 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 blah. And the taxpayer went out and did what he wanted and then tried to come after the enrolled agent for giving him bad advice. Okay. A person who only furnishes typing, copying, or mechanical assistance, that would be like a secretary, right? If your secretary is just copying papers for you or typing certain things out, then they're not considered preparers and they don't have to have a PTIN. A person who prepares the return of his employer. This would be an officer or an employee of the employer. Okay, so in this case, we're not talking about tax preparers working for a tax preparation firm. Of course, you are working for an employer, but you're preparing other individuals' tax returns. What I'm talking about is I'm working for a landscaping company, and I'm the bookkeeper, and I prepare the tax return of the landscaping company, not other taxpayers. If I'm a bookkeeper and I prepare the tax return just for the landscaping company, including their payroll returns, then I don't have to have a PTIN. I'm not a preparer, okay, for the purpose of this. Because the tax return that I prepared is my employer, okay? I'm not preparing tax returns for the public. A fiduciary who prepares tax returns for a trust or an estate is not a preparer. An unpaid volunteer who prepares tax assistance for VITA or TCPE, which is tax counseling for the elderly. They're not preparers. They're given limited practice rights, by the way, on 2848. So there's all kinds of special rules that go into this type of volunteer tax assistance because the IRS really likes these programs. It helps a lot of people out. But they're not considered preparers. If they screw up on a return royally, the whole idea is that they were volunteers to begin with. They're unpaid. So even if they're doing like rep work for the taxpayer and everything else, they're not going to be considered preparers for the PTIN requirement either. Although most of them do have PTINs, but they don't have to have PTINs. And any employee of the IRS who performs official duties by preparing a tax return for a taxpayer who requests it. A taxpayer can go in and say, hey man, I have a billion unfiled returns, I don't have any money, can you please prepare my returns? And the IRS will do it if you request it. Incidentally, Elvis did this. Elvis, the singer, ain't no. That singer hated accountants, didn't trust them, trusted the IRS more than they trusted accountants, and so he would never have an accountant prepare his tax return. He would always use the Internal Revenue Service to prepare his tax return. He would have them prepare his tax return, and there were years where he paid up to 90% of his income because he did this. He just didn't trust accountants for whatever reason. He had like an irrational fear of them. And so,
90%?
Yeah, he paid there were some years where he paid up to 90% of his taxable income in tax because he didn't trust accountants. And you can look this up, it's like trivia. But yeah, the IRS will prepare your tax return if you request it. A PTIN is not an EFIN, so don't confuse this. And the IRS likes to go back and forth between using the name of something and using the abbreviation. So it is entirely possible that you will see PTIN on your exam and then see electronic filing identification number when they talk about an EFIN. I don't know why they do this, but they do this. A PTIN and EFIN are not the same thing.
Oh, I remember this question. I'll say a preparer is identified by his or her PTIN or his or her EFIN. Yeah, so they try to trip you up.
Yeah, it's a trick question. The EFIN, you have to apply for an EFIN as a preparer, but the EFIN is tied to the location. Okay, you can have 10 preparers using the same EFIN at one location. The PTIN is tied to the preparer themselves. A preparer cannot share a PTIN. A preparer cannot share a PTIN. And if you go on Craigslist, and I've been asked this myself. If you go on Craigslist, sometimes you will see tax professionals asking to borrow another person's PTIN because their PTIN has been revoked.
Oh my God.
I'll give you $10 for each tax return that I prepare, because you can't e-file a return now. You get a critical error. You gotta have a PTIN there. Do not confuse the PTIN with an EFIN. So the EFIN is going to be issued to individuals who's been approved as authorized e-file providers. So I set up shop. I've had an EFIN forever. I've had an EFIN since before I had a PTIN, and I've had an EFIN well before I was an EA. So the EFIN thing's been around for a long time. I had to go in and do the fingerprints at the police station. I don't know if it's changed. I ordered a fingerprint card, and I had to do the fingerprints to get the EFIN. It might have changed now. Do you have an EFIN?
I do.
Yeah, did you have to do that,
I
the fingerprints?
remember.
I remembered I had to do that. I went down to the Sacramento Police Department right here on Freeport, and I sat there and waited. And there's a crazy person in there at the same time who's screaming about somebody stole their car. So it was a very, it was a very surreal experience. I'm like, I've never been in a police station. This is not like the programs. It's not nice and clean and scary. Currently, the IRS e-file program does not accept foreign preparers without a social security number who live and work abroad. So generally what ends up happening is if you have a foreign preparer, they will generally have an ITIN, but they can't get an EFIN without a social security number. You got to have a valid social security number in order to qualify. But they can obtain a PTIN, and then they're exempt from the e-file requirements. The IRS keeps saying they're working on this. We're working on it. We're working on it. We're working on it. We're working on it. But they haven't solved the problem yet. I don't know why they don't just require these foreign preparers to go to like a U.S. embassy and prove who they are. I feel like that would be a very easy solution to this problem. There's embassies in every country. They could do it, and that would solve the issue, but they do not. All right. Okay, a substantial portion rule. Only persons who prepare all or substantial portion of a tax return is considered a preparer of the return. This is a kind of a confusing concept sometimes for preparers, because if you have a tax office, a little independent tax office, then you're preparing the returns and you're preparing the whole return. It doesn't make a whole lot of sense that you might have a substantial portion. However, if you work for a larger tax firm, like a CPA firm, it is not unusual to have an entity where there are multiple schedules that are being worked on by multiple CPAs. That's a very common scenario. This CPA is working on the Schedule E because this person owns 25 separate rentals. This person is working on the Schedule C because this person also has $175,000 in self-employment income coming in. This person is working on Schedule D because this person has 70,000 capital gain and loss transactions. So that's a very common scenario once you get into like the higher income thresholds, right? These people have 1 million trusts coming in and stuff like that. I remember, who's the one that ran against, was it Obama and he lost?
McCain?
No. The next one, the Mormon guy.
Mitt
Romney. Mitt Romney. Okay. So Mitt Romney is a good example. I think, he released his tax return to the public, so probably it's still out there in the wild. This stuff is, once it's on the internet, it's out there forever. You can actually go and see his tax return. And he had multiple foreign trusts, so his tax return is like this. He had like 14 foreign trusts, and then he had a bunch of royalties coming in. He had capital gain transactions coming in. I don't think he had wages, because that would be, he was like...
He'd have to pay FICA.
He'd have to pay FICA on it.
20,000.
I mean, he's a multi-million millionaire. So he had money coming in from lots of different sources. In that case, he actually had like a team of tax attorneys and CPAs preparing just that one return. And that's not a $500 return. That's probably not even a $5,000 return, right? If you make $150 million a year, you're paying a lot for your tax return. And when you have an independent office, I feel like it's kind of unusual to see a tax return that's over $1,500 or $2,000, unless you're talking about an entity. But that's not an unusual thing if you have like a wealthy client base, okay? Because if somebody makes $1.5 million or $10 million or whatever, I'm not charging them just $400 for their tax return. Their tax return has a lot of stuff going on, right? It's not just going to be a Schedule C guy. Enrolled agent licensing. As outlined in Circular 230, there are 2 tracks to becoming an EA. All of us are going to take the test, right? That's how we became enrolled agents, or how we become enrolled agents. The first track, the EA candidate has to apply for PTIN. You got to do that first before you do anything else. That's the first step. Step number 1. Got to be a PTIN. And then you have to register to take the EA exam. An applicant must be at least 18 years old. Used to be 21, and now it's 18. It got lowered. I actually looked this up because somebody emailed me to ask me this question. They said, what's the youngest an EA can be? And I said, I don't know the answer to that. I'm going to look that up. So you got to be at least 18 years of age. However, that doesn't apply to CPAs. The youngest CPA in history was she passed the CPA exam last year or the year before, and she's 16. It's a girl. It's an Indian girl, I think. So she's 16 years old, and she's already in college. She's one of those Doogie Howser, what is it, a prodigy? So she's probably not having a whole lot of fun in her life. She's just reading all day. But she passed the CPA exam and became a CPA at 16 or 17 years of age or something like that. So she was a minor. But you can't even take the EA exam unless you're 18. So that's a moot point. There's never going to be a 16-year-old EA. You've got to achieve passing scores on all 3 parts. So you got to pass part 1, part 2, and part 3. If you fail a part, which is pretty common, people will sometimes fail part 2 and then have to take it again. If you fail a part, you can take that same part up to 4 times in the same testing cycle. I think the CPA exam is the same. You get 4 tries to take it in the same testing cycle. You have 18 months once you start taking the exam to pass all 3 parts before your passing scores drop off. Usually I recommend that once you start this train going, you gotta try to pass all 3 parts before the season is over. So if you fail part 2, just pay attention, to the parts that were hard for you. And remember, I got to go home and study those parts. If you get slammed with the state tax questions, there's a very good chance that you're going to get slammed with the state tax questions if you take it a month later. So go home and study as much about estates as you can, right? It could be anything. I'm not just saying estates. It could be anything. But like I said, when I took the EA exam, I got slammed with partnership tax questions. And that's what I got hit with. I went home and I studied partnerships like mad, and then I passed it the next time around. I probably barely passed it because it was still really difficult conceptually for me. But hey, that's like that old joke, right? What do they call the person who finishes last in medical school? Doctor. So it doesn't matter whether you get 100% or you pass just squeaking. The pass is a pass. You're an EA at that point, right? Don't forget this. After you pass, they don't just send you the EA license. You also have to file Form 23, and this is when the background check happens. It doesn't happen before. It happens with the Form 23. And they kind of dig into your life a little bit. They make sure that you don't have any outstanding tax returns that you haven't filed. They make sure that you've been compliant. I do know of at least a few enrolled agents or colleagues where maybe they skipped a couple returns when they were in college and they filed late or whatever, and they will usually slap your hand a little bit and say, we know that you were delinquent back in 1986, but we are gonna let you just make sure that you don't do it in the future. So a couple of delinquent returns in your past are not going to necessarily tank your enrolled agent licensing. They will usually let you do it anyway. But you have to be up to date now when you apply. If you have 7 delinquent returns, they're not going to give you the license. You also have to pass a background check conducted by the IRS, and they do a background check. The other track, which is not going to apply to any of us, is an EA candidate who's worked for the IRS for a minimum of 5 years. I have heard that a lot of people will just try to get their 5 years in and then get, they don't want to work for the IRS until they retire. So they'll just try to get their 5 years in, and they will get their experience, they will get the EA license, and they will quit and then go out and do their own thing, okay? A lot of these people are the ones that go into rep work, because they have all this experience with what the IRS is going to be asking them for and everything. A lot of these people do rep work. And I did an interview with a tax professional that did this. That tax pro had worked for the IRS for, 10 years or something like that. He was a big beefy guy. And he quit, got his EA license, and the way that he started his practice is he went down to the courthouse. And people that owe money to the IRS and to the state, it's public. Their tax liens are public. So he went down to the courthouse, I guess. I've never done this because I don't want those clients. But he went down to the courthouse and he took all these names down and all of their information, and he contacted these people directly. If they owed more than $10,000, he called them and he said, hey, my name is Jim Jones. Do you want to get this monkey off your back? Because I can help you. And then that's how he got his client base. It was all these like tax delinquents. That's how he started. And so that is a practice model, right? That you can pursue if that's what you want to do. Okay? Denial of enrollment. Any individual who is involved in disreputable conduct is subject to disciplinary action or denial of enrollment. They can also revoke your enrollment. Disreputable acts alone may be grounds for denial of enrollment even after the candidate has passed the exam. Failure to file timely tax returns is the thing that will usually tank it. Okay? If you're delinquent filing when you apply, the IRS is not going to give you the EA license. You have to be up to date. That doesn't mean that you can't be on extension, because I basically file on extension every single year. An extension is not the same as being delinquent, obviously. But if you have multiple years of unfiled returns for either your business or yourself, then you might have a problem. The IRS, or the RPO, which is the Return Preparer Office. This is not the Office of Professional Responsibility. This is a completely different entity there. They're related, but it's not the same. The Return Preparer Office must inform the applicant of the reason he is denied enrollment. The applicant is then allowed to file a written appeal to the Office of Professional Responsibility. So RPO is the one that says, you're out of luck. We're not going to let you have the EA license. And then when you file the appeal, it's with the Office of Professional Responsibility. You got to file the appeal within 30 days of the date of the notice. So if you don't receive the notice, you're in trouble. The appeal must be filed along with the candidate's reasoning why the enrollment application should be accepted. I have had this happen with one colleague where it was a theft issue. Somebody else had gotten a hold of one of his tax returns, and it would be so easy to do this. Somebody else, some sneaky scumbag preparer, got a hold of his tax return, one of the tax returns that he had prepared, and they started fraudulently using his name and his PTIN on their fraudulent tax returns. And he had all of these fraud EITC claims sitting out there under his name and PTIN. And of course he didn't know. How would you know, right? He didn't know, and when he applied for enrolled agent status, he was denied under that basis because they were already starting the investigations. But the preparer was like in the wind, you know what I mean? It wasn't him. And you know, if you think about it, how often do you have a client come in and say, I'd like to see your ID so that I can know that you're really this person? Have you ever had that happen? Have you ever had a client come in and ask to see your driver's license? I've never had anybody come in and ask to see my licensing. I have it on the wall, but they never ask me that. They just trust I am who I am, right? I'm gonna say, but it would be so easy then for some scummy dude to just get your PTIN information and all your preparer information. It's right down here. Your address, your name, even your signature, right? It's all down here, and then your PTIN is there, and they steal it, right? They steal it, and then they start filing fraudulent tax returns using your name.
Is there anywhere that we can check ourselves to find out if there's anything like that going on?
You can check. You can go online, and the IRS, even if you're an unenrolled preparer, there's a way that you go online. You go into the PTIN system where you log in. You can log in and see the CPE hours that you have, and you can see how many returns have been filed under your PTIN. So they don't tell you who they are. That would be very useful information. But if you filed over 50, okay, so under 50, they're not going to report it. But if you filed over 50, you can see how many are reported under your PTIN for that year. And that number should match what's in your software, obviously. And if you're way off, if it's coming up with a crazy number, then you know there might be a problem. In that case, I think you should jump on maybe asking.
So the IRS doesn't, even under the e-services, they don't have a system where you can log in with your own personal login under e-services and take a look at all those names, at the very least names of everything that's been e-filed under your PTIN.
No, there's no way for us to check. They only give you the number of returns that are filed under your PTIN. They only give you the number. And then the other thing that you can request, it's not available online, but you can request who is under your CAF number. So you can request to see like who is listed under your CAF number for rep work. Those are the only two things that you can ask, and that's obtainable. But no, you cannot check that. It's frightening for me.
It is.
You know, it's frightening for me. It can happen to anybody. He was able to work it out. He was able to work it out, but the whole idea is that this can happen to you, right? And then you're in a bad place. Renewal of enrollment. Enrolled agents have to renew their enrollment every 3 years. To renew, you have to file Form 8554 to practice before the Internal Revenue Service and submit the required non-refundable fee. They have said, and the IRS has stated that the main reason why renewals do not get accepted is because people will forget to enclose the check. And the renewal form also has to have an original signature. It can't be a photocopy. So I guess a lot of preparers are like making a photocopy and then accidentally mailing the photocopy instead of the, because that form is signed under penalty of perjury. So it has to be an original signature. It has to be a wet signature. As part of the renewal process, the IRS will check the EA's filing history. A couple years back, I've renewed several times already, but a couple years back, I did not get the renewal form. Non-receipt of the renewal form, I moved. I had recently moved, and then it was not forwarded to me. Not receiving the renewal form does not excuse you from the renewal. And the way that I discovered it was that I pulled out my treasury card to make a copy of it for some reason, and I looked at the date, and I had like 2 weeks. Because I don't look at that all the time, and I was like, oh, you know, I didn't get the renewal form, so you better believe I filed it that day. I did it like via certified mail because it was terrifying for me. I was like, oh my God.
So where can you go to look it up?
Oh, it's on your certificate. It's on your enrollment certificate. It's on your enrollment, effective the date, and then they also tell you, you get that treasury card. Wait, no, I'm lying. You get your treasury card every time you renew. That little card that you cut out, and that has the expiration date on there. I can go get it so you guys can see it afterwards. But as part of the renewal process, yeah, they check your filing history. And in the past, the IRS used to just say, have you done the CPE, the required CPE? And you would have to attest under penalty of perjury that you had. The IRS, I guess they kept catching people that weren't telling the truth about this. So now the CPE providers are reporting online. And you have to have, we're going to go over the minimums that you have to have. The CPE is 72 hours in each cycle. Okay, so it's 72 hours for 3 years. You got to have a minimum of 72 hours for 3 years. It's 100% they're going to ask you about this. They always ask this. So you have to have a minimum of 72 hours over 3 years. You have to have a minimum of 2 ethics hours per year. If you do not take ethics per year, it doesn't matter if you have 150 CPE hours. You have not fulfilled your CPE requirement. So every year, 2 hours of ethics. And this is something that I usually do like in December at the last minute. I go and try to find an online course that I can just do real quick. I don't know if I could actually get credit for teaching ethics. I bet you I probably could, but I don't risk it. I just go in and I take a class from some CPE provider and I do it. So 2 hours of ethics per year, and then a minimum of 16 hours per year. This is the minimum. You could take 16 this year, 16 next year, and then make up all the rest, because 16 times 3 doesn't equal 72. So you got to make it up at some point, but it's minimum 16 per year. Usually this is 2 classes, right? 16 is 2 8-hour classes, 18 hours. So this would be 2 days of CPE, right? And you can usually pick this up at like the IRS tax forum or online or whatever. It's pretty easy to fulfill this.
So what if you didn't take any ethics in year 1 and you took like 4 in year 2?
You have not fulfilled the requirement. So that's bad. You're in trouble. Ethics courses have to be taken every year. If a candidate takes more than 2 hours of ethics courses during a single year, the additional hours may count towards the overall requirements per year. So if you take 4 hours of ethics this year, then it counts towards the rest of the hours, the other hours. But the fact, I can take 3 ethics classes this year, but I have not fulfilled my ethics requirement for the rest of the time. You gotta take ethics every year. Every year you gotta take ethics. There's no ifs, ands, or buts about that. Okay, inactive and terminated EAs. The RPO is going to notify an EA who fails to fulfill his requirements, okay? The notice will be sent first class mail explaining the reason for the non-compliance. Notice this doesn't say certified mail. So if you don't get that notice, tough noogies. What I always tell people is you gotta really make sure that you keep your address updated with the Internal Revenue Service RPO. Your personal tax return is not going to necessarily update your address with RPO, okay? I think when you update your address when you renew your PTIN, maybe it does, but I can't even tell you that for sure. The IRS is like a big, huge agency, and I don't know how much they actually communicate with one another, all right? Then EA has 60 days from the date of the notice to respond to this initial notice. If no response is received, they get 60 days. Remember, that's not the same as the other one. The other one was 30 days. If no response is received, the EA will move to an inactive status on April 1st. If his termination, if he doesn't agree with the termination, the EA has to file a written protest within 30 days and provide a valid reason for not renewing on time. So there's an exception. There's an exception in the law that has actually occurred. We put it in the book. It was a tax professional who got called up to active duty in the military. He was over there and he was like fighting bad guys or whatever, and he didn't renew because of that. Now remember, there's tons of combat exceptions, right? The combat exception, I guess, it's not specifically in the law, but the return preparer office allowed the combat exception in this case as well and said, okay, you're all right. We will allow you to renew late and it will not tank your status. And then we will allow you to take your CPE late, or we will absolve you of your CPE requirement during the time that you were in a combat zone. So they allowed for that, okay? Losing the eligibility to practice. Tax practitioners can lose their eligibility to practice for the following reasons: not doing the CPE, not renewing the PTIN. For some reason, there's a lot of preparers out there that are really pissed off that the PTIN costs money. And every year they got to pay like $60. I think it's $50 this year. It actually went down. They're really mad about it, and they don't want to pay that money. The PTIN fees actually pay for the return preparer office. There's like the fees go into running that division, and they don't like it. But if you don't have a PTIN, if you don't renew the PTIN, you can lose your eligibility to practice. You can also voluntarily be placed on inactive status, and this does happen. Sometimes they will voluntarily choose to be retired. If you are disciplined by state regulatory agents, and this is an example of that is an attorney might be disbarred from practice at the state level or a CPA. If your license is revoked, you cannot practice before the IRS even if it's an unrelated issue.